Hello, I'm Stephen Goh, the author of The Return of Breaking Law, an ex-judge's guide to your legal rights and winning in court or losing well. I bored you rigid last month on the subject of mediation in civil cases and how we're likely to see judges ordering parties to ongoing cases to try and settle through that medium, whether they liked it or not, especially, I reckoned, in county court small claims. What's up with you?
I haven't woken up yet from that mediation video.
You wouldn't think he used to work for a BBC, would you? I promise not to bore you this time. Well, at least I'll try. Mediation is still the topic, but it's mediation in family cases I'm on about today. Disputes between parents and others about the welfare of children, and punch-ups after divorces and other relationship breakdowns over who gets what and where Fifi is going to live and who is to pay for their treats. The government announced the other week that it's decided not to legislate so as to make mediation compulsory in family cases. The judge may tie you up and gag you while they explain why mediation is the best thing since Marmite sandwiches.
Other fillings are available. I prefer peanut butter.
But the judge will not be able to order that you must go through with mediation. What the courts will be able to do, though, is to put additional pressure on warring parties to attempt to settle their differences through mediation out of court. That is thanks, or no thanks, depending on where you stand, to family law changes coming into force on the 29th of April 2024, which I previously threatened to inflict on you. First, the meeting with a mediator, which you generally have to attend before starting most cases involving a child's welfare and applications for money and property after divorce and other family relationship breakdown. Well, it's only a meeting for around 45 minutes, at which you will find out whether mediation could help you and how it works. There are exemptions from having to attend this meeting, such as the urgency in having to start the case. Come the 29th of April next, though, these exemptions are being tightened up, and the mediator at the meeting when it takes place will have to engage in a bit of triaging by considering with you means of resolving the dispute out of court other than mediation, thereby robbing themselves of the opportunity to charge you up for a series of mediation sessions with the other party that they might otherwise have been up for conducting. Incidentally, the government scheme to contribute £500 a couple towards mediation session costs, well, that continues. The £500 is produced in voucher form, which goes to the mediator, so you can't blow it on 24 so copies of The Return of Breaking Law.
Shame.
Quite. Second, the court will be given a new power to order a party to come up with a written statement setting out their views on attempting to settle through some out-of-court dispute resolution, such as mediation. If they're refusing to countenance any form of dispute resolution, they will need to come up with some pretty good excuse. They kick me under the desk, or I'm terrified to be in the same room as her for longer than 2 seconds. Or else what? Refusing to countenance without good reason could result in you being ordered to pay the other side's legal costs at the end of the case, even if you got what you wanted. A party who wants to mediate, but faced with an intransigent partner who flatly refuses to mediate, will be able to apply for an order compelling the partner to make one of those statements about dispute resolution views where the court isn't showing signs of taking the initiative in making such an order for a statement itself. It could be a useful strategy. And the government has announced an extension of a trial scheme which is suited to family cases where there are allegations of domestic violence. Under the scheme, the various agencies which have already been involved with a family, such as police or local authorities' social services, will share information which will be looked at by the judge at an early stage of the case and with a view to it being unnecessary for the victim to have to endure reliving their experiences by going into a witness box and giving long evidence about it all. The scheme's been tried out successfully for the last 2 years in family courts in Bournemouth, Weymouth, Carnarvon, Mold, Prestatyn and Wrexham, where it's now coming to courts in Birmingham and South East Wales. Eventually, the scheme is set to run throughout England and Wales. Incidentally, if you're an influencer in hot pants, Premier League footballer, you must have made not less than 6 first-team appearances this season or scored twice on the halfway line, or read the autocue on a breakfast television show, and your divorce finances are about to be decided by the court with no mediation, which you refuse on the ground that the paparazzi would have snapped you going in, you may well find a reporter sitting at the back of the court with a notebook or pencil, or both. Or do they use a tablet and pencil now? That is because from the end of last month, January, reporters are being let into these hearings at London's Central Family Court and at the family courts in Birmingham and Leeds. They can already come into a hearing of certain children cases at a number of courts, to which a further 16 are being added. They won't be let into the financial dispute resolution appointment in maintenance and property cases, though, at which the judge bangs heads together before any final hearing takes place. And the judge will have a discretion to keep the reporter out for good reason. Identities will be protected, and anything else the judge considers shouldn't be published can also be banned. If you have an aversion to reporters or pencils, and you both agree, you can have your case arbitrated out of court. Costly, but nice. If you're going it alone in court proceedings, a litigant in person, you might be tempted to use artificial intelligence to help you put together a legal argument or for documents for the court. You know, just a teeny-weeny bit of help the size of a peanut with stunted growth. The Lady Chief Justice, aided and abetted by various other legal luminaries, has recently issued guidance for judges on the use of AI. They can use it as a secondary tool and don't have to own up to it in the judgment. And lawyers can use it too, says the guidance, provided they do so responsibly and independently verify the accuracy of their AI research and references to apparently previous cases which they're relying on as precedents. So if judges do it, lawyers do it, why shouldn't litigants do it?
Birds do it. Bees do it.
Well, the guidance recognises that litigants in person are now using AI chatbots and that they may be their only source of advice or assistance.
Haven't they heard of the return of breaking law?
Quite. But remember, these are judges we're talking about. They don't know much about comics. Anyway, the guidance says that if it appears that a litigant in person may have made use of an AI chatbot, the judge may inquire about this and ask what checks for accuracy, if any, have been undertaken. So be prepared. Well, this advice is fair enough. After all, take the case of the lady last December 2023 who was appealing to a tribunal against a penalty for not informing the taxman about her liability for capital gains tax. She was contending that she had a reasonable excuse for not doing so. She drew the tribunal's attention to 9 previous tribunal cases in which the reasonable excuse defence had succeeded. She said a friend had helped her source them, and it was evident that AI had been used. All well and good, except that every one of the 9 cases was a fantasy. None of them were genuine, or the lady hadn't realised this.
Did she win the appeal?
Strangely not. Quite apart from AI, litigants in person generally have it tough when they mess up on court proceedings in a civil case. They cannot expect special treatment just because they didn't know the ropes and were doing their best when their best wasn't good enough. Having said that, some judges may occasionally be persuaded to be slightly more lenient than they would be with a transgressing qualified lawyer when they muck up procedurally. But this is how one High Court judge put it in a case last year. Litigants in person need to understand that, other than in trivial respects, the court is not going simply to ignore their failure to follow the appropriate procedures, or worse, to treat them as though they had in fact complied. That is not fair on those who do comply. A failure to follow the rules is not without consequences. It imposes extra costs on other litigants who, if they are commercial enterprises, may have to pass those costs on to their customers in higher prices, and makes litigation slower and more complicated, and thus more expensive for everyone. More court and judge time is needed to deal simply with putting things right, rather than advancing the resolution process. This generally not only makes things worse for the litigants themselves, but it also lengthens the time that must be spent by other litigants in waiting their turn to be heard. In another case, just before the High Court, a couple were appealing against what had happened at a previous hearing. They'd been ordered to come up with a written transcript of the court's judgment of that previous hearing to be used on the appeal. They failed to do so. They maintained that the transcript wasn't necessary, and anyway, that it was too expensive. They'd actually got a quote for a transcript of the whole hearing, not simply the judgment, which may have been quite short. But they'd been ordered to come up with the judgment, for heaven's sakes. It wouldn't have been surprising, therefore, if the appeal judge had thrown out the appeal on the strength of their refusal to follow the court order. After all, as he pointed out, the factors relied on by the couple, they were litigants in person, living abroad, elderly and impoverished, weren't good enough reasons for breaking the court order. But the judge gave them one last chance to get the transcript by the 1st of March 2024, next month. Well, we'll see. What drew my particular attention to the case was the judge's criticism of the couple for persistently and irrelevantly quoting in correspondence to the court a Latin maxim which means you cannot bring a court case which involves relying on your own wrongdoing. Now, let's see if the Mayor of Ambridge can spout out that maxim. Go for it, Link!
Extirpi causa non orator actio.
Better than I expected. Remember the late Peter Cook on Latin?
Yes, I'd have liked to have been a judge. But I never had the Latin. I never had sufficient Latin to get through the rigorous judging exams. They're very rigorous, the judging exams. They're noted for their rigour. People come staggering out saying, oh my God, what a rigorous exam. So I become a miner instead, a coal miner. They're not so rigorous, the mining exams. They only ask you one question. They say, who are you? And I got 75%.
So when you write to the court, stick to the English if you can, and steer clear of the maxim.
Nemo dat quod non habet.
De minimis non curat lex, I would say. And the rain should clear up later.